We're here again, fortunately, with Bradley Knight, and I'm Fabrice Bardsley for the third part of our conversation about adventures in legal land. And we're going to start off with covering a few bits about being a MacKenzie friend.
Yeah, thanks Fabrice, I appreciate it. I appreciate you taking the time, because obviously you're taking time out to upload these videos and post them, so it really is appreciated. So that's great. I think what we said was, one thing I would like to say is none of this is structured. We have a brief couple of minutes chat beforehand.
Yeah.
And we kind of look at topics, but the topics could be endless that we could talk about. But we've picked a couple that we could think that would help people for today. So MacKenzie Friend, what I wanted to we discussed it last time. What I thought, considering I've just left a court case, assisting someone as a MacKenzie Friend, is how difficult it is for the person that you're assisting. Now in this case it went fine, perfectly fine. As a MacKenzie Friend, so you need to consider that as a route or an avenue you go down. Because I'm not necessarily saying you should do that or get a lawyer or a barrister or whatever. I'm not saying you should do that. I'm not saying any avenue. But what I'm saying is, and the reason why I'm mentioning this, because it's something that Vin James mentioned, and I thought actually that guy's spot on, is the psychology of the courtroom environment.
Yes.
Is extremely difficult. Now, it isn't difficult for me because I've had the benefit, and also my cock's not on the block, so to speak. Yeah,
that makes a very big difference when
massively.
It's especially if they're threatening you with large ramifications as the proceedings go on.
Yeah.
The psychology is really important, also for your frame of mind, because you can be fully equipped with a fantastic bundle and everything that you need to know.
And it's easy to forget what pages goes where, whatever.
Yeah, and especially if your knees start knocking together, your hands start getting sweaty, you think your heart rate is going to start ripping through your chest. Yeah. It's very, very difficult to do that. But I've had some experience coaching children and young adults with drama. And it's the old adage.
I'm a drama queen, by the way.
Yeah, well, you don't get worse with practicing. So the more you practice being a drama queen, or the more you practice working in court, usually the easier it gets. And I think part of that role play, if you're fortunate enough to get in a situation where you think, you know what, that magistrate, that's nowhere near as scary as the person I was role playing with last week, then you get more confident, and when you start to see those sort of things. So,
but one thing, the thing that I learned, and it's probably I probably knew this in the back of my mind, but I didn't realise it, is the psychology for these people. I mean, what I experienced today, and the reason why I thought it was pertinent to talk about, is that even though I prepped them, and we're talking about role play because you mentioned that, I prepped them, I was in the courtroom saying stuff in their ear.
Yeah. It
went nowhere.
Okay.
It went nowhere. It was just kind of like if I was a buzzing bee. Now, but also what I learned from today, and it's fresh in my mind, and that's why I said we should talk about it, because Vin mentioned this the other day, and I don't see it, to be honest, because I deal with so many cases. It's just I'm not saying it's just a conveyor belt, but I approach it. Actually, on that point, I approach it very differently, all these cases, to be fair. And I have a very personal empathy level to each of them. But basically, what I realised in today was that actually the litigant person still, even though you've got a MacKenzie Friend, struggles.
Yes.
Struggles.
Yeah.
Really struggles to take on board and to control those different voices in the room. Because I was even saying, giving guidance today, and I was saying stuff to her. She's saying, but hang on, I need to hear over there. But I already realised that we didn't need to hear that.
Yeah.
But that person didn't know that. It gets so difficult for them.
Yeah, and I think that's part of that role-playing technique as well. And one thing that we find very useful when we're doing UK court role play is changing the roles. So that if somebody has some ideas of what you might say as a litigant, then if you go and pretend to be the judge, you might understand what positions the judge can do, or the prosecutor.
Exactly, but one thing I realised, this has probably happened before, I've never really noticed it, and this is my psychology, I suppose. I was saying, focus, just listen to what I'm saying, ignore what's going on around, just listen, and that person couldn't do that. Man, ultimately, it was fine, and she placed, she placed the right words on the record. But it was very difficult for me to just say, kind of stop, just listen, just focus on me, just say these words.
But do you find that in court, if you're a litigant in person, that sometimes the bench and the prosecution, you're talking about the conveyor belt, they want to push things along. So sometimes the person that you may be assisting feels that pressure and doesn't quite hear you when you say, you can stop and take a breather?
Okay, this is an example, actually, perfect example, I suppose, is what I impart on people, if I can be brutally honest, is say nothing. Just wait. Let everybody say whatever they want to say and make notes on what they've said. And then look at something in what they've said that you think actually is pertinent that you need to raise, and get the judge to answer that, or the other party to answer that. There's something that very important that people need to do in courtroom procedure is try not to be the opening party. As a litigant person, normally the judge would automatically look to the other side if they've got a lawyer, barrister or whatever. Let them do that. That's great. Because you may learn something that you never knew. And then you take that approach. But you know, it is a stressful environment. I recognise that. It really is. And it's difficult for me to say to people, don't be worried. Because that's not quite true. You know, because things could happen in court.
I mean, you're going into a place where there are, as I said, cross-dressing control freaks who have control over their court, and they're quite. They make no bones about that. So it is an intimidating place to be. But with, I suppose it's like anything. If you're going to go on stage or if you're going to appear in front of a camera, then the more you do it, hopefully,
I mean,
easier it
there's
becomes.
stuff people that do that I can't do. I'll be honest. Like, there's stuff. I mean, I'm not on about. I mean, public speaking, for example. I've done it, but it's not something I enjoy.
And sometimes you can have people who can function in one environment perfectly well. They can stand up in front of a stage with 2,000 people. And be perfectly, or seemingly professional and relaxed. But actually, an audience of 5 people in a small courtroom.
Actually, this is kind of why I kind of like courtroom, I suppose, is because someone's confronting me, almost like attacking me, and I can be responsive to that. But if, for example, I'm let's just say proactively talking, I know this we're talking. I'm not looking that way that much, but basically I've got an intention here just to share information. But what I'm saying is, if I had to give a lecture, that's not me.
Sometimes you can cross over from one skill set to another, so that some of the skills you may have as a public speaker, or even the confidence, for example, or even as a footballer. If you can remember scoring a goal, a fantastic goal, then when you were productive, when you read the situation right, then you'll be in a positive state. If you meditate on that state before you go into court, then that gives you every chance of being confident and on the ball.
This is actually kind of funny, actually. Actually, you just mentioned meditation. That's actually kind of funny, because I remember Danny Shine. I love the guy. He said to me, "Bear with me, Brad." This is what he said, and he did it. And I watched it. He said, "I just need to compose myself," and he just stood there for 30 seconds, and he was doing this meditation thing or whatever, and I went hell for leather on his microphone, gramophone,
megaphone.
Whatever you call it, yeah. But in the courtroom, he flakes. Isn't that interesting?
Yeah.
Now, if you flip that, I couldn't do the megaphone bit.
Well, funnily enough, having done a bit of both, there's a few clips out there of going on a megaphone. It's the 7 P's: prior proper preparation prevents poor performance, I think is the one. So a little bit of practice, a little bit of idea. Proper prior preparation prevents piss poor performance, I think is the 7 P's. Right up there with our 6 little honest men: who, what, where, when, why, and how. So when you practice, and then you can like I said, that confidence can come across, because everybody's different. So you listen to yourself.
Do you think there's a construct you could apply to it though, or is it just mental training or something, or what? Or how do you see it that could help people watching this video? I mean,
well, again, practice also knowing who you're dealing with, and this is we spoke a little bit about the right to silence and listening to what people say before they expect anything from you. Which is, as you were saying, that the other side have their say. But it's also in terms of knowing your position, or being zen, I suppose, because sometimes you can have judges
being zen.
Yeah.
Okay.
So.
Should we start singing "Come By Ya" or something?
Well, no. It just means whatever energy that they're taking. If somebody's being inquisitorial with you, you don't necessarily have to take that energy.
Right.
But stay centered in your own energy. But and so sometimes you can feel that there is that pressure. And the more you can kind of hold your own rhythm, which is why I suppose the more practice you can have with MacKenzie Friend. And sometimes we have hand signals. So if you tap somebody's leg as a MacKenzie Friend, if they know,
you do that suggestively then.
Well, you know, the signal is finish your sentence, and then we'll talk about what we're.
Yeah, exactly.
You know,
this is the most important thing. What people need to realise, and this is your safety belt in core. You're a litigant person, even though you've got a MacKenzie Friend or not, or a friend, is that you do not understand. Just slow the whole process down. Just really do. And effectively, as long as you slow it down from the start and during, and don't advance any, don't suddenly think, fuck me, I'm winning, I'm going to fucking just talk away about my mouth off. Don't. Just know you're winning and deliver the same slow down wording, language, whatever it is you're going to use. It's very, very important, because the thing is... And
also I find the intensity of your language as well. Again, the slower that is, the more productive it is.
Yeah. The benefit you do have is by slowing things down, your let's use the word arguments, your arguments are more considered. And I assure people listening to this, there is no problem whatsoever if you say to the judge, excuse me, I need to think about this.
Yeah.
Because if he says no, that's an appeal.
Yeah.
So just bear that in mind. So if you want to go and get a cup of coffee, and he may say, well, we've only got an hour, well, fuck it, I don't care.
Yeah.
You know, let's relist it. Because obviously there's a reason why you need to get it considered.
Yes.
And you'll get that relief as a litigating person, because, again, if he doesn't give you that, you say, okay, fine, I'm leaving. Because I need to think about this.
Yeah.
And that's your exit. If he obviously, ideally, what you want to do is be able to consider a question and answer, but you need to make sure it's a considered response, because it's on the record. Now, magistrate's obviously completely different, but you know, county court, crown court, high court, Queen's Bench, Chancery, whatever, it's all on the record. So you want to make sure you deliver something, and the judge may not even know what you're delivering. And I know it's difficult for people, I know, but basically, you may not even... I want to be careful about what I say, but basically what you're laying the foundations for is the appeal. So you may want to lay a question that you don't even want the answer to. So you just got to be very considered about how you act in court.
Yeah, and this is often something that comes up in plea hearings, where you know you're going to ask them a question that they're not going to appreciate answering. You know they're going to put in a not guilty plea regardless, simply to move the process along, and you know that when you appeal that they're going to be recused from the bench for the next hearing.
Let's okay. Sorry to interrupt, because my mind works in overtime sometimes, and I've just thought about something else, of an example in terms of how judges conduct themselves. Let's just say appeal.
Mm-hmm.
I know this is basically from experiences in the past. Is the judge will read the appeal, but even on the appeal, they will interpret my appeal to be something different to what I'm applying for.
Mm-hmm.
So I let them run off and go through, and basically what they do is, because the appeal judge doesn't want that appeal to happen. I'll be perfectly frank. They don't. They don't want to basically take up court's time.
Mm-hmm.
But what they do is, which is great, is the distraction game. Don't worry about what's going on over here. Look over there.
Yeah.
And basically what you do is allow them to expose all the criticisms. Fine, great. Okay, I appreciate what you're saying over there, but what about this?
Yeah.
That's what people need to get their mind about and structure around, is don't necessarily take an offence to all their opinions or all these arguments. Like, you know, someone may say I'm a fucking fat bastard or whatever. I don't worry about that, but what about the other bits that I'm interested in?
Have you followed the due process to establish that I am a fat bastard?
Yeah, exactly. Yeah, exactly.
And that can often be,
Yeah.
you know, the example of that shell game, if you like.
Take the bits that you can grab from it and take merit from, and that's what people need to structure their minds about. Is just don't worry about the conjecture. Focus on the standing, the holding, and that. Sorry, I'm sorry about that.
And no, it's interesting, because it's part of that element of not being a trained lawyer and not having.
I'm not a lawyer.
And not having, you know, a QC or a barrister.
Yeah.
Is that you can ask those questions.
That's your best relief.
Say, I'm not a lawyer, I don't understand
this. Yes,
Can
absolutely.
you say that not in Latin but in English?
Yeah,
and in common sense terms.
Yeah.
And do you find that puts the pressure on them? Justice not just needs to be done, but needs to be seen to be done.
Think about this logically, yeah. If in the scenario that we painted, is if he says no, how the hell can that judge stand up and say, or have standing on whatever happens after that court case?
Yes, especially if you've asked them prior to that and were entitled to a fair hearing.
Exactly right. Yeah.
So
entitled to a fair hearing. That's it's a good question to ask. But the assumption is that obviously that is the case, and obviously we discussed this last time. Oh, well, actually not yourself. Someone else interviewed me, but we discussed this subject specifically. Actually, presumed innocence is struggling to exist in UK courts. The presumption is not quite there. What they're looking, to be honest, I think criminal courts is more on the balance of probabilities now rather than the presumption of innocence.
Well, I mean, and I think that's why it's vital that whenever people do go into court, that they're established. Am I presumed innocent of the charges? Am I presumed innocent of every element of the charges?
Yes, you're laying the foundations for them to, for you to then say, for example, well, you said the presumption of innocence was always there, already there. Exactly right. Yes,
and
absolutely.
Also, the same for, you know, am I entitled to a fair hearing? Am I entitled to a meaningful hearing? By meaningful, I mean, if I don't understand the cause and nature of these proceedings, can I expect a responsive answer?
Yes, exactly.
And once the judge has said that, or once the bench has said that, then that established the precedent, because it's not just written in a book, the judge has confirmed.
Yeah, let's just stop on that thought, is do not get offended or get angry or get passionate about their responses. All you want is an answer. Like I say, all I'm thinking of is the appeal. I'm not thinking about the case at hand, because that's not going to affect your life on the day, generally speaking.
Yeah.
Because if it's criminal, you've got probation reports, all that sort of stuff. But what you're looking for is a response.
Yes.
And that's what you know, what people end up doing in my experience, based on YouTube videos that I've seen, is what they do is get pissed off at the fucking judge, and then start getting passionate, and they lose the track of what you're looking to do. So I'm sorry to interject, Fabrice.
It's a common gaslighting.
It's hard
technique.
though. I know it's hard.
A very common technique because it's. I'm sorry, Brad. I'm so offended by what you said. I'm no longer going to talk to you anymore.
Yes.
And it's their version of doing that. I'm sorry. You're very passionate. We're now actually not going to listen to your arguments. We're just going to address the tone of your voice and proceed to railroad this because it's easier to deal with that than
the best thing to do though, right? As an example, would be is like, for example, if you ask a question, you go in very docile into court. If I'm honest, that's the best demeanour to put. Yeah. And if they don't answer your question, gosh. So basically, this means this, and that means that. Okay, let me think about that. Conduct it like that.
Yes.
If you're struggling. You know.
Yeah, and often, actually, even if you're not struggling, sometimes I find it's very useful to be in touch with your inner Forrest Gump and ask the very simple questions. Am I presumed innocent?
Yeah. Okay. Something that's again talking about relief, and relief basically means is what it says. You get relief of something, and a word that I think people should research. And I try and stay away from legalese as best as I can. I leave that for the upper courts. Is unfair advantage. Now, as a litigant person, basically is you're at an unfair advantage automatically because there's normally, unless there's two litigants against each other, there's an unfair advantage because they're legally qualified.
Yeah.
Technically speaking, and it doesn't apply because it's just the system that we're in, is that party, the other party, if they've got a lawyer, barrister, whatever, would need to be, they can't, there's a conflict of interest, they advise both parties, but they must disclose everything to the court. They must disclose everything.
Okay.
So for basically, this is where you use the unfair advantage argument, but actually it's an unfair advantage on them.
Yes.
Because effectively you've got an exit every single time.
Yeah.
Because you can explore many different avenues and you use your unfair advantage position as much as you possibly can if you're losing in your case. So unfair advantage is a great tool as a litigant person which the judiciary have to address because there's plenty of case law in it. Plenty of case law, and I don't like case, going down all that sort of shit. But to be honest, in my mind, just going back to what I said earlier, is what I'm thinking of is what if, maybe, could be, should be.
Yeah.
I'm looking that way. So all I'm looking for, and this is what people should get in their head in court, is you want them to say something, even if it's against you, and you want them to put a statement down, even if it's against you. You want it, because then you can start looking at the holes.
Yeah, you can see the nature of that statement, the validity of it, or not.
And if you want to exit the courtroom, you use the unfair advantage tool. So
yeah, and again, that's not being a lawyer and needing time to have consideration.
Yeah. And this is a huge issue for the judiciary at the moment. The amount of litigants per person nowadays. Well, because of legal aid.
I checked some of the statistics, and again, it is 1 in 5 now in magistrates' court. They are much keener to try and encourage people not to litigate in person in more senior courts. But that's 20% of people who are going to magistrates' court who could be open to.
On that point, actually, there's something we haven't discussed, but we did intend to discuss, and this is how this often friggin' happens, to be honest, is what people would ask themselves. Let's just say they go to a duty solicitor. What difference does that duty solicitor do for you than what you could say yourself? What law does that duty solicitor quote in court?
There's usually very, very little.
Okay, I would assert none.
decent criminal's evidence.
The only thing that the solicitor can help you on is on the judgment and the scale they apply.
Mm-hmm.
That's it.
Mm-hmm.
They cannot help you. All they can do is talk for you to make sure you do not say things you shouldn't say.
Mm-hmm.
Now, my principle and what we've discussed previously and even today is that you say nothing anyway.
Yeah.
Let them bring everything forward.
Mm-hmm. Mm-hmm.
So that duty solicitor doesn't have a function in the magistrate's court on a simple road traffic.
Mm-hmm. And the other thing,
whatever.
The other thing that solicitor more than likely will not do is actually listen to you.
Well, no, he couldn't express a response for you.
Yeah.
Right, because he's talking to the magistrate, and if the magistrate says something or the prosecutor says something, unless you're tapping him on the shoulder, he's not going to listen to you. He's just going to look at his 5-minute brief,
Mm-hmm.
but you've lived it.
Yeah,
You
and
know.
also there are occasions when people do have requests that they want to make, information they want to find out, and even if a solicitor takes instruction, they often don't follow through with it. Your chance of recourse is relatively little. More often than not, they get paid, win or lose, and that's often the motivation.
They always get paid.
Yeah.
That's the disadvantage. You know,
Mm.
the loser in the room is somebody, but it's not them. That's for sure.
Yeah.
Yeah.
Yeah. And I think peace of mind is one of the biggest things, because it's so very difficult to get in a courtroom.
It's difficult to do what, sir?
It's difficult to get peace of mind in a courtroom.
Right.
That's often one of the hardest things we were mentioning earlier for litigants in person, to go into court and feel calm and feel as if they're at ease with what is going on.
Right.
And that's why I feel role playing can be really useful in that way, in terms of keeping people calm, but also going and sitting in court before you get there, going and seeing a courtroom, because then you can see when solicitors aren't actually doing their job, and they're like, actually I'm just going to get paid anyway.
I think a lot of it, if people just applied logic to it, but it's hard to omit the stress, and I understand that, but you know, I've seen the sharpest minds in the room fold in a courtroom.
Yeah, and it can be done. But it's one of the hard things is that people get put through that ordeal, and it is an ordeal, for sometimes some of the most ridiculous things, such as traffic in Danny Shine's case. You know, speaking through a megaphone, or taking your children on holiday.
Yeah. We got all his 5 cases dropped, by the way, all of them, just by asking questions. And although we did have to attend the Crown Court.
But how many people who don't have the resolve of Danny Shine or aren't able to access the
he's suing them now.
The support, brilliant. You know, actually just get steamrolled because they're intimidated. They're going there and I was going to ask questions, but they said if I give them £150, this will all go away. And I want it to go away really badly now. You know.
That's the sad thing about the way the system is constructed, and this is where it's so difficult for me to give anybody any guidance. Is it's leveraged against you? That's for a fact. It is leveraged against you. But sometimes you think, well, let's just pay the £60 ticket.
Yeah.
Just be done with it. Yeah.
Well,
if you fight it, you're at risk of ending up £500, something like that.
Yeah, and it's up to everybody to make their own decision for their own case at their own time, whether they wish to get a solicitor, a brief, whether to ask questions, or whether to just pay the pictures of the Queen to make it go away.
Yeah.
And I feel the more options that people can explore, again, it's that peace of mind. The more options people can explore, then usually the happier they are with the options that they decide to pursue.
Yeah.
And again, it's sometimes people have those decisions to make. But sometimes some of the most,
But the problem is, it's an unfair
offences.
decision, though. You think about that example; it's unfair because let's just assume that you have an argument, a legal argument or position to put forward. What I'm trying to say is that you not only got to challenge the system, but it's unfair on you, because you think about your mindset. That is it fucking worth it? I suppose.
Yeah.
That's basically, and and I really respect people to take either route. I understand it.
Yeah.
I understand it. I understand that. It makes perfect sense to just pay the 60 quid and be gone. That's it. It's out your head.
Yeah.
Dealt with. Or if you fight it, I respect that as well.
Mm-hmm.
Because I prefer the fighting route, if I'm honest. Especially with that
it's
sort
not
of
the appropriate
stuff.
thing for,
I
everybody
definitely.
at every time.
I
it's good for people to know that they do have the options of asking those questions.
Yeah.
And seeing actually, how do I become, beholden to a school for them to choose when I take my kids out? How do I become, beholden to British Rail to not sing and dance when I want to sing and dance?
Yeah.
And sometimes when you ask those questions, as you obviously found in Danny's case, they have no answers.
I mean,
but how much is it going to cost you to get to them to say they've got no answers?
The fact they have no answers is also very good, because what you say is, when you get to court, you've had no disclosure. And what I'm saying is that on that point is if you get no answers, that's a good thing as well.
Yeah.
It's good.
It is a good thing, but for example, if you get no answers at a plea hearing, as we have transcripts of, a magistrate will say, well, if it goes past this plea hearing, you're going to be hammered for more costs.
Yeah, it's a threat. That's a threat.
Yeah, that's a threat.
Actually,
so you return and say, well, I would like to plea, but you haven't given me the information here.
Yeah.
And then they proceed to steamroller you with that threat hanging over. Again, the magistrate's often recused, you can get your plea withdrawn, but you still have that experience. And for some people, that's like, well, actually, I'm just going to pay this and have it done today. And that's why I think for the unfair advantage you do have to not be legally trained is something that actually people should really be aware of, because that can make the difference between them feeling confident by threats.
Absolutely. Okay, school, you mentioned that.
I mentioned, attendance at school. There are quite a few people have in recent years, when they've wanted to take their children out of school for a holiday, or sometimes if their child has had bullying issues, or if they've changed schools.
Okay.
Sometimes if it's happened during a school year, it can be difficult. People often ask for help and support from the Education Welfare Office. And find that they give them some information, and the next thing they know is that they get a notice of intended prosecution through their door, or worse. So, and do you have any thoughts on how best to?
Okay, this is where I go back. A word I mentioned last time is contract. That's in video number 1. I brushed over it only because I didn't want to go into that subject. But bear in mind, none of these videos are actually structured with any defined subject matter, although you did mention that you wanted to talk about that. What you've got to ask yourself, right, if you think about any contract, there's parties. There could be more than 2, 4, 5, 6 or 7, right? Ask yourself, at what point did you subscribe to you saying that you're going to commit your kids to a school, let alone the school that they're at, a school that they will be there, and they'll be required. This is the interesting thing. It's what you've got to understand. Required to be in attendance for all this period of time. Think about that. Think about it as a contract.
Well, I think there is a contract per se. I think there's I guess a notice of intention when you register a child at school. But
well, it's a registration to say they want to attend school. Now,
but
think about this as well. Let's just say, for example, like in my case, I registered my kids 5-6 years ago at the school, yeah? If there's an addendum to that, which is basically what's happening to people now,
yeah,
I should be notified. What happens if I wasn't notified?
Well, the contract would be invalid because there'd be no meeting of minds and there'd be
Well,
no consideration.
Let's not even get that clever. All you can simply say is, I don't have a clue what you're on about.
Okay.
That's it.
Yeah.
And they're gonna say to you, well, surely you must do because you would have known about this. Well, when did you notify me? Now, what I can say, this is going back to not being too clever, is I got confronted with the same issue a couple of years ago. I got called into school and they said to me, I don't think it's reasonable that your kids should have 4 holidays a year. And I said the complete opposite. I said, actually, I'd like them to have more. I just can't afford it. And they couldn't answer the question. And they said, well, you're disrespecting the school. And that wasn't it. I actually told them up front, I said, we really like the school. We really like the school. Because if you think about it, look at it in just, I'm using Vin's word here, psychology. Does that, if they're questioning my approach, I'm not taking if my kids want to go away and they're consenting, fine, everybody's consenting in that circle. Now, using Vin's psychology approach, which is fantastic, the way he explained it to me the other day, does that mean then I can question everything they do? So when they say, for example, we're going to play board games all day, do I question that?
Yes.
The natural, the natural human being wouldn't do that.
Yeah.
But what they're saying is, oh, the government says this. Oh, fine. But where's the notice? Where's the paperwork? Where's the chain?
Where's the obligation? Where's the evidence? Where's the... and it's a very good question. I know Vin uses, I believe, the Trivium method for
Trivium,
people who want to...
Yeah. He mentioned that, I don't really know anything about it.
Well, it's very similar to Mark's technique in terms of you defining your terms. You use logic and...
Dean seems to know quite a lot about it, actually.
What Stephen Molyneux calls universally preferable behaviour, which is basically...
That's Stefan guy, actually, on that
basically means the rules that apply to you apply to me.
Right. Is that what
the
it
rules
means,
that apply to them, universally preferable. So the same rules apply to everybody in exactly the same way. So you combine that with...
so Trivium means what? What does that mean?
I'm sure Vin would explain it better. I'll
he was just dropping the word. I didn't know what he meant. I've never heard it.
Essentially, it's using logic, reason, and having structure in that. So to a certain degree, you can you discount emotional judgments.
Right. Okay.
Whether you call something good or bad actually defines on the terms you're using. So if it's productive, then it could be construed as good, if that's your judgment on it. And,
so Trivium means what then?
I'm not. I don't use the term myself. I know that's what
so Trivium means application, is it? Or something? Or?
I'm not sure. I think it's.
Let's brush that one over.
Yeah, I think it's the universally preferable technique, using logic and qualifying. You're defining your terms.
Okay.
And the absence of carrying any weight with emotional.
Right.
Well, it's tradition. We've always done it that way.
Gotcha.
Okay, it's not going to cut any mustard in terms of let's have the logic, the reason, the analysis behind it.
Yeah.
And those techniques help an awful lot. And it's interesting to apply, as you call common sense, to establish a level playing field.
Yeah.
Because you're perfectly correct. For them to question whether your child should go on holiday and whether it would be beneficial for them. Exactly. Do you question whether they're going to play cricket or football or
Well, you think about it. Go back to the school thing as well. I would almost describe it as they're interfering.
Yeah. Well. And it is that. Unless they can substantiate any of their charges, then
you don't want them to substantiate anything. How could they substantiate it? Yeah, it's true.
Yeah.
They were there or they were not.
Yeah.
Because the benefit, the precursor as well, what you've got to also consider as well, for example, in my personal experience, my personal case with this issue, is we're proactive parents. You know, we're good parents. Our kids have a good education and a good lifestyle and living at home. Is we even say to the school beforehand, give them some homework so that you can do stuff. Not least because it will keep their minds busy for a period of time. So if you just look at common sense, isn't that quite a natural approach?
And can I ask you, did the school actually give them homework?
No.
No, they didn't.
No.
And they never do, because that.
Well, our kids like study, so.
Yeah, that for them. I mean, this is where you show good faith in this particular field. That they don't. They feel it encourages parents to have their children outside of school. So even if the child can't attend for whatever reason, be it health, be it mental health, be it for some other reason, schools will not actually support that child's continuing learning unless they have total control over it. So I can understand why people can often feel quite upset when they do have that type of interference.
Yeah, I think it's. I think. Listen, this is. Let's put this in perspective. Yeah, what benefit does society get by fining parents for taking their kids out of school?
Commercial benefit.
But what benefit does society get? Like, for example, if you got fined, what benefit do I get?
Well, I don't know if there is more attendance because of the threats, but that would probably be it.
It's basically you're not playing to the rules. That's it. And we want some money off you for that reason. Yeah. That's basically. That's what you've got to sum it up by. But look at that instance, that specific subject matter as a contract. Now, don't do that as a rule of thumb. But look at it as a contract. That's the way you should treat that. Yeah. Is as a contract. So hopefully people can learn something from that, because that's a good subject, and it's certainly something that's bounded about at the moment.
Yeah. And it's interesting because sometimes you can have those kind of charges against you. For school attendance.
£1,100 someone. Yeah.
That's
it was in the Daily Mail I read. What do they call it? Daily bullshit or whatever?
Daily Fail, I think.
Daily Fail, that's the word.
It's the one, or the Daily Chimp, because it's written by chimps and typewriters. As the that's as far as we know so far. But if you do get a fine like that, and sometimes with these new court costs that we were talking about earlier, that aren't means tested or don't appear to be means tested.
Means test is very important.
Well, you get the bailiffs then, and that can be a very intimidatory thing to happen, because some bailiffs can be quite professional in what they do. I have to say that. Some can be outright criminal in what they do, and can threaten people and menace people and harass them, and can seek to force their way into people's homes where they have no authority, reason and justification for doing so. And that's one that people come across, I think, probably more and more with the economic situation nowadays, and sometimes how reactionary some local authorities can be in sending bailiffs to engage with people. And the bailiffs do have regulations, I believe. I think it's a section 15 that they have to have before they can they have to agree a section 15 with the party they're claiming on.
Okay.
Before they can retrieve any goods.
It was called agree a section 15.
It's whereby you agree with the bailiffs what goods they're going to remove as settlement of what charge.
Is this a levy or something?
No, that's their authority. You have to give them, participate with them and negotiate with them for their authority to remove goods. After that has happened, then they're entitled to gain entry to your house to remove those goods. So sometimes that can be agreed in court. The bailiffs will come at a later date and do that, but usually
So let's talk through that, because I'm kind of lost. So the bailiff will knock on your door. I know about bailiffs, right?
Okay.
So but the bailiffs will knock on your door and say, "Will you sign a section 15?"
In theory.
And they should. Well, what I'm saying is they should say that.
They should ask for settlement of the debt,
right.
And then if it goes towards removing goods,
right.
if they're looking towards removing goods, then they have to agree a section 15, I believe.
Right.
I'm not entirely sure. I'm not a lawyer. I'm
actually
not qualified, but
people, if you're out there, answer it.
Yeah.
Comment on this video, because I don't know, and I'm probably not going to have time to think about this subject. But bailiffs. Okay, let's talk about bailiffs. I don't like them, the scumbags. It's a job that I cannot imagine gives anybody any satisfaction, other than financial. So I can tell you, this is not advice. Definitely not advice. Do not do this. What I've done. Do not do it. But I've done it twice. For example, when I got my car clamped twice. I've cut it off, but I give them prior notice to say I'm doing it. There is a precursor to that. The precursor is I've told them that their paperwork is invalid, which it is, always is invalid in my experience. Mm-hmm. Gave them notice, cut it off with an angle grinder, dropped it down to the police station. Do not follow this. Do not do this. This is not advice. Got arrested and explained, because I had all my paperwork in order, and it's not a lot of paperwork, it's very, very simple, just as simple as their paperwork. Their paperwork is normally 1 page. You know, I at least have a little bit of passion towards it. I have at least 3 or 4 pages, you know, in terms of my notices. So I left it by the front door, knew I was going to get picked up by the police. Funny enough, one time I got arrested, the police said, "Are you the guy that cut the clamp?" I said, who are you looking for? He said, "Do you want that car there?" I said, "Yeah." He said, "Okay, we're looking for you." So, so they didn't even know my name. So the complaining bailiff made a complaint. They mentioned a name, but it wasn't my name.
Okay.
Even though I gave them notice, and this is not your relief. Your relief is not the notice. The precursor was the relief, because I basically made them perfectly aware that if they did something, they're at risk. The bailiff come round, clamped the car one morning, and so I cut it off with an angle grinder. I mean, massive inconvenience to me to get an angle grinder, get an extension lead out. Oh my God, the stress. And then have to drop it down to the police station. But what I'm saying...
There's never a parking clamp lying around when you need one.
What I'm saying is, I did the prep work if something did happen. Now, obviously, I don't want to be clamped anyway, regardless. Yeah. So I cut it off, got arrested, got interviewed. I actually talked in the interview. The reason why I talked in the interview, because it was they didn't know it. Actually, I was questioning them.
Oh, okay.
So it was structured. So that happened once, and got released from the police station. It's only about an hour, I think I was there. Second time, the actual police officers took me home. And that was the end of it. But like I say, that is definitely do not do that. But all I'm saying is, I think what you can learn from that is get your ducks in a row. Mm-hmm. Make sure you've got your legal paperwork, because if you've got your legal paperwork, because what you've got to understand, police are there for criminal, they're not there for civil. Mm-hmm. This is a civil dispute. If that bailiff then wanted to sue me for criminal damage, like he accused me of, fine, bring it. If he sues me, which I'd love him to do, I'm going to do a massive counterclaim.
Yeah, and the legislation has recently been clarified and updated with that, so that as far as I'm aware, that police officers are now not allowed to engage in civil bailiff's claims unless there is a criminal element to it. And
how does that affect evictions?
I'm not sure if if they're liable for, or if the police service is liable for any officer acting on a warrant which isn't valid. which is a new change. I haven't looked at the
Well,
exact
actually, it can't be a change
legislation.
anyway, because if they're acting on an invalid warrant, it's moot anyway, isn't it?
Yeah, but it's their duty to protect. If they're acting on an invalid warrant in the belief that it is a valid warrant, then they're protected.
Yeah.
Whereas I believe now that's not quite the case, but I wish to look into legislation further.
Yeah, I don't know anything.
And exactly what the situation is with civil claims for property, and whether the police are allowed to be involved in that. Again, I don't know. I'd have to have a look at the legislation in further detail,
aware,
but it has just been changed. So.
Based on Dean Kirby has told me about this. I rely on him to give me information that's relevant. He sifts stuff quite quickly. Or actually, he listens to the detail and says, "Actually, Brad, look at this, because this would be quite helpful." So I am aware of this, but I know absolutely nothing about it, so I can't comment. But it wouldn't take me too long to get the substance to it to be able to advise people, not advise people, give guidance.
And again, I feel that bailiffs can often have that similarity to any appearance in court, because it can be intimidating. It can affect your peace of mind. Often when people are banging at your door unexpectedly, it can be hard to be in the right frame of mind to actually question their paperwork.
Do you know what? This is
and see if they've dotted their T's, crossed their I's, and stamped their warrants.
This is what people. Let me try and impart this then, right? Bailiffs work on fear like the courts, but they do it in your face. And I would going back to we seem to have a theme of Mark Stevens, but ask questions, validate it. Actually, that's a good point.
And also record as well. We have technology these days.
That's a good point you've just touched on in terms of courtroom connecting bailiffs. It's actually exactly the same approach you should have. It's the same application, and I know it's difficult. It's very stressful. And the police are ignorant to bailiffs. They think, well, they've got authority, man in a suit, so to speak, got a badge, all that sort of stuff. And both of them have got badges, so we're going for it. And they think you're a nut job. And sometimes people say the wrong words. All you've got to say is, for example, I don't understand. I need to think about this. I need to get legal advice. Close the door, and just think about it. You know, I definitely, obviously, I would never pay a bailiff.
And again, also, when you film as well, that can give
definitely
you a piece
record everything.
Gives you a piece of.
You would not believe the amount of mistakes they make.
And again, how many times has recording an incident like that with bailiffs who haven't been acting properly assisted in the matter going away?
But don't publish it though, because if there's something that you've got a claim for, do not publish it online at that time. Just sit back, relax.
The general rule of thumb is wait till the matter is resolved.
Yeah, exactly.
As it can. It can prejudice, it can come back and bite you. It can also allow the other side to create a fiction that will enable them not to be responsible for their actions.
Yeah, well, you're giving disclosure. They're going to know what they said. Yeah. Because I guarantee you they would come out with some shit during that conversation at the doorstep. So, so definitely, don't publish it online. I'm saying do publish it, but when the matter's resolved. So you can hear the sort of shit.
I know this for role play. In case people are interested, there's a UK role play group on Skype that can be quite useful for practicing.
So what do they do? Just type in UK group.
UK court roleplay, I think, is there, or if they'd like to, they can always contact me on Skype, on Facebook, on YouTube, through the usual channels, and I'll do my best to put you in touch with the group.
Roleplay is very, very important. Very important.
And hopefully in the future, it's been great having some of these informal discussions, and hopefully we'll be able to do a couple of structured pieces that can maybe talk through some people's experiences in court, and so that again we can show why people ask, am I entitled to a fair trial, am I entitled to a meaningful trial, am I presumed innocent, of the elements of the charges, so that's more comfortable and practiced for people who do want to ask those questions.